Good afternoon, everybody. I'm Kara Mitchell. I'm an Associate General Counsel at Children's Healthcare of Atlanta and also part of the Executive Committee of the Nonprofit section. Thank you for joining us this afternoon. We're going to kick right off with nonprofit organizations and insurance, key insights, market updates, and some lessons learned. And then we'll be followed with advising nonprofits on document retention, destruction, and production. We're glad to be joined this afternoon by Brent Reese and Dave Matthews of Sterling Seacrest Pritchard. Brent serves as the Director of Risk Management for Sterling Seacrest Pritchard, primarily focusing on risk management advice, support, and resources for the agency's clients, and advocating for clients when faced with claims, litigation, coverage disputes, and the like. Prior to joining SSP, Brent held several executive leadership positions at a large medical professional liability insurance carrier in Atlanta, including COO of the Risk Management Department and VP of Underwriting. Brent has also practiced law at several firms, including his own solo firm, Brent S. Reese, PC. He graduated from the University of Georgia in 1992 with a degree in risk management and insurance and obtained his law degree from Georgia State in 2000. Dave joined Pritchard and Jordan in 1992 and is now a partner and client advisor with Sterling Seacrest Pritchard. He specializes in risk management and insurance programs for public and private corporations with a concentration in nonprofits. In addition, Dave has held several advisory council and board positions at nonprofits, including Camp Twin Lakes, YMCA of Metro Atlanta, and Zoo Atlanta. He's a Leadership Atlanta alumni, co-founder of the annual leadership conference, and founder of the semi-annual Camp Leadership Roundtable. He earned his bachelor's degree from Miami University. And with that, gentlemen, I will turn control over to you. Thank you.
Thank you, Kara. I appreciate that. And thank you so much for having us. We really appreciate the opportunity. I'm going to go ahead and start sharing my slide deck. And hopefully you see it now. Brent, can you see our slide deck?
Yes.
All right, awesome. Thank you so much. All right, let's go ahead and get started then. All right, so we've got a lot to go through today. There are a tremendous amount of topics as Brent and I were preparing for this to talk about when it comes to nonprofit insurance, but we're hitting what we believe are the highlights today and what you, if you're working with nonprofits, kind of should be aware of as to what challenges they're facing in some of the insurance issues we are seeing today. So we're going to talk about the insurance marketplace as a whole, because I think that's very important and part of what we're seeing when it comes to rates and premiums. Talk about Georgia's litigious environment, insurance for nonprofits, abuse. We've got to point out many nonprofits are working with kids and vulnerable adults. We'll talk about some loss scenarios that we have seen, as well as some contractual risk transfer. So yeah, there's a little bit about Brent and I. I don't think there's much here that was not already discussed in the introduction from Kara. So Kara, thank you so much again. And Brent, why don't you tell the folks a little bit more about SSP?
Yeah, so like Dave said, thanks everybody for having us. Dave and I both work for SSP, Sterling Seacrest Pritchard. We're in different roles at Sterling. Dave is on the production side. He places clients' business with the various insurance companies that we work with. I'm on the service side. I'm on the risk management and claims advocacy side. So what that means is I will work with our clients on the front end to develop risk management programs to hopefully avoid them getting into claims. But when they are in claims, when they do get involved with a claim or a potential claim, I get involved at that point as well. They'll report that to me, the incident or whatever occurred. I'll figure out what insurance may be in play for that particular situation, and then I'll stay involved in that claim throughout the claim process, just to make sure it's handled appropriately by the insurance carrier. I can just tell you from experience, there's a lot of green, inexperienced claims adjusters out there who like to just rubber stamp declinations without really doing a deep dive into the coverage. And so I've got to kind of keep them honest, so to speak, in my role to make sure they're handling the claim appropriately. But real quick about Sterling Seacrest Pritchard, we are one of the largest privately held risk management and insurance brokerage firms in the United States. We're licensed in all 50 states. We've got 6 offices primarily in the Southeast, and have about 360 employees, and we're growing. Relative to nonprofits, and Dave can talk more about this, but we pretty much handle the whole gamut of nonprofits, from schools, churches, foundations, associations, senior living, social services, camps, arts, etc. So there's no nonprofit that we don't have that we can't handle their coverage for, and that goes for any line of business. Quite honestly, I think we write every line of coverage in our agency, again, across the United States. So if you'll go to the next slide.
Sure, yep. And I think I'd only add, last count, we had about 70 nonprofits as clients, and many of them are local, but many of them also have regional, national, and international exposure. So you'll see some of that represented in our slides today too. So when we look at risk management in the process, we look at several different cogs kind of working together. One is we're going to evaluate the risk of the nonprofit and then develop some risk strategies. And some 4 we've got outlined here. Certainly risk avoidance is simply not doing the task or the activity that's going to pose risk to the organization. Like, we're not going to put in a swimming pool because we don't want drowning risk. We can retain risk if we think the risk is small and manageable. So perhaps the nonprofit has just a few volunteers, and we really aren't that interested or think we're that exposed to volunteer accident coverage. We're not going to buy that type of policy. The nonprofit certainly can reduce its risk by putting safety strategies and policies and procedures in place. And of course, they transfer the risk. And so we'll talk a little bit today about risk transfer, contractual risk transfer to perhaps vendors or third parties on our site. And of course, you transfer risk to insurance companies by buying insurance products. We'll talk about those insurance products. And then certainly the nonprofits are no stranger to claims. We've got plenty of claims out there that we can share with you, and we'll talk about some of those lessons too. But first, Brent, why don't you tell us a little bit more about some pre-claim strategies and some things that the attorney should be aware of?
Yeah, so I'm going to be looking at this from a high-level standpoint, and then Dave at the end of the program is going to get more granular with nonprofits, et cetera. But I want to go through what I called my top 5 recommendations to attorneys with respect to representing your clients and the insurance issues that come into play. I'm going to start with the pre-claim recommendations. And the first is finding out who the defense panel is with respect to each of these insurance policies that your clients may have. Oftentimes attorneys, when they're representing clients, they won't know who is available as defense counsel until a claim arises. And what I would recommend you do, because as you know, all of these insurance companies have a pre-approved defense counsel panel. And I would recommend that either through us or another broker or directly with the insurance carrier, finding out on the front end who those attorneys are. The reason that's important is twofold. One, you may have somebody on that panel that you know that you feel comfortable with your client working with for that particular insurance policy coverage. And so you can, on the front end, go ahead and make clear to the insurance company, hey, we like this attorney. We want to work with this attorney should a claim ever come up. And they can actually go ahead and note that in their system or even possibly endorse it on the policy in terms of who you've asked to serve as defense counsel if a claim arises. Also, if you're an expert in a particular area, and I'll just talk about like employment practice liability coverage as one example, and if the premium is high enough, right? So, everything, money talks, right? So if your client is paying enough to this insurance company premium wise, and you have some expertise potentially in that area of coverage, you potentially could actually be added by endorsement as approved defense counsel for your client. Now, no promises there. Again, it's really going to depend on how much experience you have in that particular area and how much premium the client's paying, but it's something to think about. Okay, I just offer that out there. The second recommendation is for you to assist your clients with insurance, new business applications, and renewal applications. I can't stress enough how important this is, because as you may know, these applications often form a part of the policy. Okay. And so when a claim comes in, the adjuster, one of the first things they're going to do is they're going to look to see what your client attested to on their application or the renewal application. And I'll give you an example of how this looks. This comes up a lot with cyber insurance. Okay. And all of these cyber liability insurance, all of these carriers now, for the most part, require the insured to have, for example, multi-factor authentication. They require them to be using it across the board. We had a client a healthcare client whose staff was going in providing healthcare services to a prison system. And they knew, these nurses, when they went in, they knew that the cell service was really bad in the prison system. So they would actually turn off their multi-factor authentication when they went in there, because they knew they'd never get the signal to be able to access the electronic health records. Well, they had a cyber claim. And again, the first thing the adjuster did is they started asking those folks involved whether or not they had multi-factor authentication activated at the time of the breach. And they had to say, no, we turned it off. And then the adjuster went back and looked at the application or the renewal app, and it said, hey, you guys attested to the fact that you're always using multi-factor authentication. And so they used that as a way to potentially deny coverage. They issued a reservation of rights letter. The client was nervous about where this was going, et cetera. So recommendation number 2, assist your clients with filling out these applications. And I also tell our clients, hey, look, if what you're attesting to affects the entire company, ask others in the company or tell them what you're attesting to before you do that. Again, multi-factor authentication is a good example. If you're saying everyone's using it, reach out to everybody in the company and say, hey, I just want to make sure everyone is in fact using this, because this is what I'm attesting to on our application. Next slide, please. Okay, and the third recommendation, pre-claim, that I would have for you, and I'm sure you're doing this already, but you need to be comparing your client's lease agreements with their property and general liability insurance coverages. Our clients will send me their lease agreement, and they'll send them to Dave too, I'm sure, and just make sure that, for example, the insurance coverage that they're required to carry mirrors what they actually have through us or through the particular property and general liability carrier. One example that I've got listed here, this is tenants improvements and betterments. This is an excerpt from an actual property policy relative to tenants improvements and betterments. For those that don't know, that it's defined here, those are fixtures, alterations, installations, or additions that your client will make to the space that they're about to lease. But they don't take those with, they become permanent fixtures to that property. So it's different than trade fixtures. It becomes a permanent part of the property, but most of these leases require them to insure those tenants improvements and betterments. We had a claim where our client went in, was leasing this new, basically had a blank slate to build out for their purposes. And so they put in around $1 million of their own money to build out this space. They added their own cabinetry, the flooring they wanted, et cetera. And then they told us when we're putting together their property policy, they told us that they had about $1 million of tenants improvements and betterments. And so that's what we insured it for. But here's the catch. As you can see in the highlighted section, the tenants improvements and betterments that the insurance company will pay for are only those that were made at the insured's expense. And in this particular situation that we ran into, the lease agreement offered the tenant, let me back up, the landlord provided a construction allowance of $250,000 as an incentive to get the tenant to take the lease. So even though they had $1 million total of tenants improvements and betterments, the landlord actually fronted $250,000 of that. Well, that became critical because when they had a partial loss of about $100,000 to their tenants improvements and betterments, the adjuster applied a 75%, 25% ratio to the loss, because they said, hey, you only paid $750,000 of the $1 million, and the landlord actually paid the other $250,000. So those were not all at your own expense. And so they applied a 75-25 ratio to the $100,000 loss that they had. So just an example of why you need to pay close attention to what the lease is requiring your client to do in terms of insurance coverage. Next slide, please. Okay, and then last two recommendations. These are post-claim recommendations. The first thing you want to do is check for insurance. Okay, and I know this is difficult. I run into this a lot, where you've got these clients and you want to kind of handle whatever they're dealing with legally. And I absolutely understand that. The problem is you could be jeopardizing coverage, because most of these policies require the insured to put the carrier on notice as soon as practicable. Okay. And so this comes up a lot, for example, with, again, going back to employment practice liability claims, where the insured will get maybe an attorney letter, or they'll get some kind of notice from the EEOC, and the attorney representing the client, their client, will just try to handle it themselves. And then they'll say, if it turns into something more, then at that point we'll put the insurance carrier on notice. But I can tell you, it happens time and time again when it does not get resolved early on, and you do end up having to put the carrier on notice. Time and time again, the carrier, the first thing they're going to say is, when did you guys first become aware of this? And if the answer is, oh, when we first got this EEOC notice, or when we first got this attorney letter, 6 months ago, the carrier is going to very likely deny coverage for that claim, because you failed to put them on notice as soon as you could. So that's one big issue that you've got to be thinking about. And then the other thing, and this is why it's really helpful to have a broker like us, is you want to make sure you've notified all the carriers that may have coverage for a potential incident or claim. So many of these carriers have, from a marketing standpoint, they'll add these kind of, I call them throw-in coverages, but the sublimits on these throw-in coverages can be considerable. They can be $25,000, $50,000, even $100,000. So if you've got a broker like us, you can just tell us about what the incident is, and then we know what all the coverages are and what throw-in coverages each carrier may have relative to that particular incident, and we can put them all on notice at one time. So that's my 5 recommendations. I'm going to turn it over to Dave now to handle the more of a deep dive on nonprofit coverage.
Awesome. Thanks, Brent. Appreciate that. All right. So as we talk about insurance, we need to kind of frame the conversation as to where the insurance marketplace is right now, because the marketplace is impacting the nonprofits. In order to do that, we need to talk about the cycle of the insurance industry, as well as define some terms. So the insurance industry, like many industries, has what we call hard and soft markets. Soft markets are going to be characterized by, premium decreases each year. Insurance companies are easily providing the limits that we want when it comes to umbrella limits, and they're also pretty agreeable on terms and conditions that we want. And those are really great marketplaces when it comes to the nonprofit and the insured. Unfortunately, we've been in a hard market for several years where premiums are increasing, capacity decreases, so underwriters are pulling back on umbrella limits and other limits that they will provide. Underwriting scrutiny becomes very difficult, and they're pulling back on terms and conditions, and we've been this way for some time on several lines of coverage. We'll talk about that in just a minute. But the hard market can happen for various factors, and it can be a combination of factors. There can be falling investment returns for the insurance company. It can be an increase in the frequency and severity of claims like natural disasters, and we've certainly have had that in several years. We'll look at that. There's social inflation and nuclear verdicts, and I'm sure all of you are aware to, Georgia's designation as a judicial hellhole. We'll talk about that in just a little bit. And of course, inflation, supply chain, especially, after COVID, increase in costs of construction materials went up, so forth. So those all kind of impacted costs to the insurance company. And insurance companies then turned around and increased those costs to the insureds. So let's take a look at where we are today. Right now, I'm kind of calling it a tale of two cities. The hard market is still in effect for property coverage. Quite honestly, we're seeing property rates go up, not as much as they were in the recent past, but still property rates are up. Auto has been a train wreck for many years, so any nonprofits that have auto fleets have been impacted. Abuse coverage, we'll spend some time on that. Sexual abuse and molestation coverage, very difficult, very hard market. The umbrella marketplace, the excess liability marketplace is difficult. Medical malpractices. So there's still some challenges, certainly, and a lot of nonprofits have access to those or have exposure to those insurance programs. On the bright side, we do have some soft markets in the workers' compensation is very competitive. The executive risk, which is directors and officers liability, employment practices and fiduciary liability. Those are seeing a lot of competition from the insurance marketplace. And from what I've seen on cyber renewals over the last year, it's been pretty competitive too. Seen a lot of renewals at flat or slightly lower, as long as the nonprofit has the appropriate protection in place. So that's a good thing. Some bright news on the horizon. But let's take a look at why we're in the hard market for some of these policies. And we'll start with the property policy. What you can see here is a trend line from 2017. And as that line goes above zero, those are property rate increases. And so the property insurance marketplace has been hard or hardening for the last several years. You can see it's tapered off a little bit as we come to Q4 2024. In this particular chart from CIAB's, the Council of Insurance Agents and Brokers, and they provide these charts on a quarterly basis. Since the property was trending well, they didn't update this, but we drew in the results. And Q4 2024, only about 6% rate increase on average for property, which is great. And you can see a nice decline from the 20.4% in Q1 2023. So that's positive news, but I would caution too much celebration there. A lot of those rate increases are from the increases in billion-dollar natural disasters that we've seen throughout the United States in the last 44 years. So this chart is from NOAA, and you can see it's from 1980 to 2024. If you look at this chart, each of those little squares is a billion-dollar natural disaster at minimum. So you can see in 1980, $1 billion natural disasters. And if you do the math from 1980 to about 2007, there are $4.7 billion natural disasters per year. But if you look at the last 5 years, that's up to $23 billion natural disasters. And certainly 2025 did not start well with the wildfires in California. And that estimates I've seen anywhere from $30 billion plus. So it looks like we're continuing to have these natural disasters. And of course, the insurance company has to fund for these and has to spread that cost out to the insureds across the country. This is a focus on 2024, the $27 billion natural disasters we had, where they came from and where they were really impacted. A lot of times we'd think about pure hurricanes around Florida, the Gulf Coast, maybe some wildfires out west, but look at the concentration of storms, tornadoes, and activity right through the Midwest. Just a lot going on everywhere. And insurance companies are trying to keep up. Not only have we been hit by natural disasters, but I also mentioned supply chain and inflation. So anytime I'm talking to a nonprofit that owns buildings, we have to talk about the increase in the replacement cost of those buildings if they are damaged by a fire or a tornado. And this is one of several indexes that we use, but it's, I think, a good base to look at. And so if you look just from 2021 to 2024, there's about a 20% increase in building replacement cost construction values. And if you go back even to 2016, it's another 20%. So if your nonprofit hasn't looked at their building replacement cost in the last several years, they're probably significantly underinsured, might not get reimbursed for what they expect or hope if they do have damage to a building, and could incur a co-insurance penalty in the policy for being underinsured. So anytime we're working with clients, for-profit or nonprofit, it doesn't matter. We're talking about building valuations. We're talking about inflation year over year. And quite honestly, insurance carriers have caught up with this because they have had to rebuild these buildings that are insured under their policies, and they understand that the cost of construction has gone up, and they are quite honestly dictating a lot of increases in building values. So the insured is getting hit with not only rate increases, but increased valuation of the buildings, and that is multiplying the premium increase that they've got. So not only property, but auto is also impacted too. And auto has been, as I said before, a train wreck for many years. This is, again, a line showing increase in auto premiums. This goes back to 2011. And you can see almost a continuous trend of increased pricing year over year. In fact, you'll see this chart says there's been 54 consecutive quarters of commercial auto premium increase. This is not just commercial, though. It's hitting all of our personal auto policies. Your cost of insurance has probably gone up too. So those nonprofits that have those auto fleets, they're getting impacted by this, and they're seeing an increase in cost. The issue is you would think that, hey, if the insurance company keeps increasing premium every year, eventually they've got to catch up and they've got to start making money. And we wish that were the case. There's a lot of numbers here, but I really want to call your attention to what I've circled in red here on the commercial auto side. That CR stands for combined ratio. And what that means is for every dollar the insurance company brings in, what they pay out in losses, as well as their fixed expenses. And you can see this stretches from 2014 to 2023, and only in 1 year did the insurance industry make money on commercial auto. And that was 2020. And we all know there were a lot of people off the road with COVID. People weren't driving for work, and it was a very different year. So what is that? 9 out of the last 10 years, the insurance company continues to lose money on auto insurance. I don't see that changing anytime soon. We're probably going to continue to see an increase in auto rates in the near future. What we ask is, well, why is this happening? There's several factors involved here. One is the increased cost in repairing vehicles. The technology in the vehicle is much more expensive than the vehicles in the old days. Certainly medical expenses are going up, so people injured in automobile accidents is costing more for the auto carriers to pay for those injuries. And of course, we've got social inflation, nuclear verdicts. We're also not getting any safer when it comes to driving. We continue to have risky driving behaviors. We're still talking on our cell phones. We're driving erratically and recklessly. Anybody who drives on 285 like I did this morning, it's kind of a daily occurrence. You cross your fingers and hope for the best. You can also see at the bottom of this chart here, the Georgia traffic fatality data. From 2013 to 2023, we're up 39%. So we're not improving in our driving records either. All right, Brent, I'm gonna turn it back for you. Talk about some of you mentioned social inflation, judicial hellhole. I'll let you take it from here.
Yeah, so I don't know if you all have seen this article is public, or this uh, report that's published by the American Tort Reform Foundation, but it's a nonprofit corporation that I'm just kind of reading from their website. Their purpose is to educate the general public about how the American civil justice system operates, the role of tort law in the civil justice system, and the impact of tort law on the private, public, and business sectors of society. For years, we weren't even anywhere near the top 10 on their judicial hellhole list. And these are the worst places from a business standpoint, defendant standpoint, to be in business. And then over the last several years, we started kind of creeping up into the top 10. And then the last few years, we were actually number 1. We've actually dropped back to number 4, which is great now, but still, and this whole report is, as I'm sure y'all have seen, is up for debate. It depends on which side you listen to. The Georgia Trial Lawyers Association, they say this is garbage, and the defense side says, this is gospel. So, but this is one reason why we're getting, that tort reform is being highlighted. I know there's a tort reform package that's in the legislature right now, Senate Bill 68, to combat this issue, right? So if I would encourage you to look through this article. It talks about all the reasons why we're on this list. Y'all seen the Ford rollover. They've had a couple of $1 billion verdicts, and I primarily work on the healthcare side, and there is, excess verdict after excess verdict. That's one of the reasons why we're on this top 10 list. So, and again, this kind of to my point, this is some of the issues that are some of the reasons why we're on this top 10 list. And again, the reason for the Senate Bill 68, again, I'm talking from a healthcare law standpoint primarily, but it's applicable across the board. Some of these things that are being addressed, that will be addressed or trying to be addressed in this new Senate bill. But for example, it's not on this list, but like anchoring, that's one of the issues, the hot topics. I've been to, as a former claims adjuster, I've been to these trials and watched firsthand how that plays out. And, what the plaintiff attorneys do is they, I was at one where they said, look, LeBron James makes $40 million playing basketball. And their client in this particular case had some kind of neurological injury and would never walk again and whatever. And so they're like, if LeBron James can make $40 million shooting a basketball, surely that's kind of the starting point for what our client is entitled to receive for all the pain and suffering that he's going through. And so those are the kind of things. And so jurors, and by the way, we when they do that, when the plaintiff attorneys do that, and then the verdict comes back at like $5 million, we've talked to jurors afterwards, and they thought that they were doing the defense team a favor. They said, oh, we thought you guys would be happy that we only awarded $5 million because the plaintiff attorney was asking for $40 million, and so we only gave them a fraction of that. So we were doing you guys a favor. So it's just interesting how that anchoring comes into the mindset of jurors. I'm just kind of looking through this list now. The other issue that comes up a lot is this third-party litigation financing, which has been, it's not something that's disclosed to the jurors, and it causes a lot of problems for the defense side, because back in the day, again, when I was managing claims as a claims adjuster, you always had a little bit of leverage with the plaintiff attorney where you could, because you knew that it was their own money that was in the case. So you could, and you knew that they were worried about not getting anything out of these personal injury cases. And so you could use that as leverage to get a decent settlement. Now with litigation financing, there's no incentive to try to resolve the case on the plaintiff side. In fact, they're probably discouraged from trying to resolve it because these backers are trying to maximize profit out of what they've invested in. So just issues like that are driving up these verdicts. There's certain counties that are worse than others. It used to be, hey, DeKalb, Fulton, Gwinnett, Clayton, all bad counties from the defense standpoint. Yeah, I mean, now if you look, there's verdicts. There was I forget the number, 30 million, I think, up in Union County. There was a huge $100-and-something million verdict up in Rabun County. So these traditionally conservative venues, they're seeing these record-breaking verdicts as well. So anyway, just another reason why we are on this judicial hellhole list, and just something to be aware of.
Yeah, so Brent, I like that term, garbage or gospel. Either way, the insurance companies are reacting to it because they are paying these claims. And we've had several insurance companies come in over the last year and talk about how they are decreasing their exposure in Georgia because of our litigious environment. And these numbers were shared with us by an insurance company just last week, and I wanted to put them in here. So this insurance company said, and let's talk about the structure of an insurance policy first, which I'm sure you all know. The insurance company puts out the primary layer, call it the first $1 million general liability policy. Then they might put up a $5 million umbrella, or they might put up more than a $5 million umbrella. In the past, they might put up 10, 15, 20, 25 million. So this insurance company came in and said to us, look, just 3-4 years ago, we had 1.5 billion in aggregate umbrella exposure in Georgia alone above 5 million. Okay, so they added up all the umbrella limit they had above 5 million in the state of Georgia, 1.5 billion. They've consciously made the decision to cut that significantly because of what's happening in Georgia. They said today we're at 150 million, so they've cut 90%. And they said by the end of this year, we're going to be at zero excess of 5 million. So you can tell, again, hard market we talked about, and a reaction to what's happening in the state of Georgia, insurance companies are significantly pulling back on limits. Of course, that makes it more difficult for the nonprofit and for us because we've got to go and find additional limits. And quite often those additional limits are more expensive than they were in the past, okay? That same insurance company who's limiting their exposure to Georgia to 5 million max said they'll easily write 10 million in other states that have more favorable environments. So how does this look? And I know it's a little complex, but bear with me. On the top is the representation of one of my clients. That's a nonprofit here in Georgia. And the same insurance company, I'm talking about the top chart here, provided a $1 million primary layer. Maybe you can see my cursor for the general liability, employee benefits, auto, professional, sexual misconduct, D&O. And they offered 5 million excess for much of it, 2 million over the sexual misconduct, 3 million over the D&O. That total policy premium in 2024 was $97,000. They had a significant change in 2025, which is what we've seen other insurance companies do. Other insurance companies, in fact, did it earlier than this year. So we've had to layer. The insurance company did provide the primary layer. Then we had to bring in additional carriers to come in. And so what was one carrier became 3 carriers, and the price went up almost triple. So this is what we're seeing happening in nonprofits. This one is a difficult one. Children in care, foster care, it's got a lot going on, but this is absolutely impacting the nonprofits and operations, right? And this money that goes to insurance does not go to mission critical services that they provide. So we've dug deep on a few. Of course, nonprofits have lots of different insurance exposures. I'm sure you're familiar with many of these types of policies. And when we have time for questions in about 10, 12 minutes, we can certainly talk about these. I don't know that any of these are very different. Certainly, flood and earthquake coverage, not huge issues here, although flood's becoming more of a concern as we see hurricanes come inland and dump large amounts of water. A lot of nonprofits provide professional services, or at least have social service professional liability. Your international nonprofits could have a kidnap and ransom exposure. Everybody's got the cyber exposure, social engineering. We see a lot of nonprofits, especially camps, have drones. And they're taking pictures of what's happening at camp and some of those things. And you've got to understand that the general liability policy has an aviation exclusion in it. And so if somebody's injured by use of that drone, it won't be covered by a general liability policy. You've got to buy some special coverage. Foreign travel for people traveling overseas, travel accident, again, people traveling for nonprofits. A lot of those that we work with do travel overseas, have offices overseas. So lots of different insurance coverages, but one that I want to spend some time on is abuse, because that is very difficult for the nonprofit industry. And so let's talk about that a little bit with some abuse prevention eye-openers. So some information, a lot of this comes from abusepreventionsystems.com. They're a provider that we use that does great training for nonprofits on abuse prevention. And there's also information here from Presidium. So if you're not familiar with those two organizations, take a look at them. They've got great information and do great work. And I'll kind of buzz through this. I know we're getting a little short on time, but 60 million abuse survivors in the United States, 1 out of 4 boys and 1 out of 6 girls abused by the time they're 18. A lot of times we think of abusers as strangers, but 90% of abuse comes from someone who is known and trusted to the family or to the victim. We've got to understand that less than 10% of abusers will ever encounter the criminal justice system. So unfortunately, a lot of nonprofits feel comfortable in that they've done a background check on employees and volunteers before they hire them, but they've got to understand that 90% of abusers will never be caught in a background check. And so they've really got to train themselves on the grooming behavior of the abuser so they can understand and spot that type of behavior. Okay. Another blind spot is often that everybody thinks, hey, it's going to be males, the abusers. Males absolutely are predominantly the abuser, but 10% of the abusers are also female. Sometimes that gets lost on people. And I'm sure many of you are aware, if you've worked with nonprofits in the last few years, there's been a significant rise, especially since COVID, on peer abuse, especially with younger children. And so that's something you've got to keep an eye on too. Just because kids are out in the playground doesn't mean something can't happen behind the scenes. So training on grooming, the grooming process is the key to prevention. The offender will groom the child and in fact groom the gatekeeper, for instance, the parent, for trust, through trust and their kindness to get to that child. So the nonprofit has to be looking at grooming and looking at training. I'm sure you're all aware of the myriad of abuse cases and claims throughout the United States. Some of these huge, certainly the nuclear verdicts over 10 million, some of these hitting $1 billion with the Boy Scouts, 2.46 billion. So gigantic claims. Just an article out a few months ago from Amwins, that the mass exit coverage in the human services industry increasingly harder to come by. You've heard me talk about certainly the large jury verdicts. The statute of limitations have changed in some states where there are revival laws and people are allowed to come back after decades and make claims. Fewer carriers are offering coverage without a doubt. We've seen premiums skyrocket, easily in a short period of time for the same or lower limits. Can be up 50 to 80% for good risks. Excuse me. And of course, carriers are reducing coverage. We've talked about that already, and we've got some examples here. Almost every nonprofit 5 years ago could easily buy 5-10 million It's hard to find 1 million excess now. Presidium put out this report. This came out just last week. They survey the insurance companies that provide this type of coverage to the nonprofit. They asked them what do they expect in the market over the next 3 years in terms of the availability in the terms of the sexual molestation coverage. 59% say it's going to continue to harden in the marketplace. So that does not bode well for finding coverage and finding it affordably in the near future. 24% do see that it'll be opening up. That's great news if that happens. And 6% says it'll be no change. Finally, they asked the carriers about limits specifically in the next 3 years. Where do you see the limits of liability for sexual molestation liability? 65% say it'll continue to decrease. So again, putting pressure on the nonprofits. If they can't buy the limits, it's difficult to protect your assets. You really have to focus on the policies and procedures to keep your kids and your vulnerable adults safe. All right, let's jump into some claims, some things that we've seen happen to nonprofits that were eye-opening to us and helped us kind of look at things differently. The top example here is many of these nonprofits have golf outings. They seem fairly innocuous. Certainly somebody getting hit by a golf ball, and that's concerning. We had one not too long ago where the golf day was done. People were driving the golf cart into the parking lot to drop off their bags in their car. One of the carts rolled backwards. Either the brake wasn't on, we don't know what, rolled across the parking lot, hit another person on the other side of the parking lot and injured their ankle. What we thought would be a really small case turned out to be a $4 million settlement, completely blew out the $1 million general liability primary policy and $3 million of the umbrella. So what we started to think about was, hey, for these special events, start writing a special event policy instead of relying on the general liability policy. We want to insulate the general liability policy for some other types of claims. So one strategy there. A lot of nonprofits own their own buildings. Some of them still have a pressure vessel. But many of them forget that a property policy does not include equipment breakdown coverage or boiler explosion. So think about adding that coverage. We brought on a new client. We added that policy, and in the first 2 years, they paid $2,000 in premium each year, and they had a $20,000 claim each year. So you don't get a return on your insurance program investment very often, but in this case, they did. And we've got a nonprofit, certainly somebody traveled overseas, forgot where they were, got in their car, traveled the wrong way on a road in the UK, caused an accident. What the nonprofits need to know is that you have to buy local liability coverage outside the US, Canada, US territories, and possessions. That even if you have a foreign liability policy, it includes auto coverage that's only excess of local admitted coverage. So if any of your nonprofits are traveling overseas, they're going to rent a vehicle, they've got to buy the local coverage. That's why I tell you, they might say, hey, my credit card covers it. I can't speak to that from an insurance standpoint. They need to buy the local coverage. Let's talk about some contractual risk transfer. We talked about that a little bit earlier. We've got a nonprofit that, nonprofits own schools. They own football fields, soccer fields, just open fields for play. Well, another organization asked if they could use that particular playground, that sporting area. They said fine. They didn't follow their procedures. They did not get a waiver. They did not get indemnification or a contract in place. Somebody was injured on that space, and now the nonprofit is being sued, and they're not going to be able to get out of it. So make sure that if third parties coming onto your premises, that there's contractual risk transfer in place. We had an example where this did happen, and we won in that we had a nonprofit that was taking cars, as donations. They took title to the car. A third party auction company picked up the car, took it to the auction house. Unfortunately, when it was going on to the stage for auction, the driver drove that car into the audience and injured over 20 people, many of them severely. Obviously, there were lots of lawsuits, a lot of legal issues going on, but we had a really strong indemnification hold harmless agreement in place, and the nonprofit did not get involved in that particular claim. So really need to think about contractual risk transfer for your nonprofits and all the vendors that they use. I'm going to skip that one for time. Brent, you talked about this one a bit. You know, obviously nonprofits get the EEOC claim. Unfortunately, a lot of times they'll turn to a board member or somebody that they know at a legal firm, and they start negotiating that particular claim, try to settle it, come back and ask for the insurance company reimbursement. And because they did not turn it into the insurance carrier in a reasonable time, the insurance carrier denies the claim. This is another example where an insured was a third party, did printing services for third parties. They unfortunately printed a document that was relied upon to make some business decisions. I think it was a benefits guide for a large employer, so thousands of benefits guides. There was a typo in it. They had to reprint those in a very short order, then came back to the insurance company and said, can you reimburse us the $40,000 for the printing cost and the overnight cost? And the insurance carrier said, no, you can't negotiate, you can't settle your claim without our involvement. So they were denied that claim. So keep that in mind. Lots of other lessons learned, but Brent, I'm going to turn it back to you. Talk about vendors, contractual insurance recommendations as we get close to time.
Yeah, I'll be real quick. The way I approach these when clients reach out to us and ask like, hey, we're going to do this with this vendor, what kind of coverage, do we need to ask them to provide? I usually start with the max, right? I give them kind of a boilerplate, like they need to have work comp, auto liability, general liability, umbrella, maybe even professional liability, and then kind of work down from there depending on who the vendor is. Because that way, for each of those coverages where the vendor says, hey, we don't have this or we don't have that, then you can kind of, okay, I know they don't have this, and two, does it make sense that they don't have this? Because again, this goes back to that contractual risk transfer issue that Dave was talking about. Ideally, you want to make all of the exposure be on the vendor, right? Because if they don't have these coverages, it's going to fall back on your client, and it may not even be covered by the policies that your client has. So you just got to be real careful with that. The other ideal thing to do is when this vendor or whoever it is does agree that they've got these coverages in place or proves that they've got these coverages in place, you want to take it a next step and say, okay, that's great, but we need to be added as an additional insured on the policies that you have in place. And most carriers will do that. It's not a big deal. They know that happens all the time, but it's got to be in writing, that requirement a lot of times for there to be coverage. So in other words, the contractual agreement has to say that the party has to be named as an additional insured in order for that coverage to trigger. You also want these other things, like you want it to say that vendor's policy is primary and ours is non-contributory, and you want a waiver of subrogation clause. You also want to make sure that they're with a carrier that's got the appropriate AM Best rating, right? You don't want some non-standard carrier that maybe doesn't have enough assets to really cover a big claim. And then lastly, you want to have, again, we talked about this earlier, what I look at in these agreements is the indemnification and the hold harmless language to make sure, like the example Dave gave with the car being auctioned, they most likely had very robust indemnification, hold harmless, and defense coverage language in that agreement to prevent your client from getting pulled into it. They can just look to the vendor or whoever it is, look to their carrier to cover the claim that's been made. So I'll stop there. I think we've got 5 minutes left.
Yeah.
Dave, you have one more slide.
Well, I think that's just the key, I think, is to make sure your nonprofit is working with a broker that does have experience in the space, especially if they have exposure to children, vulnerable adults, foster care, adoption, those types of things. There are not that many insurance companies out there that are doing this. They need to have access to those companies, be able to benchmark, bring value-added services, risk transfer we've talked about. There's just a lot going on with nonprofits, and they need somebody who knows how to work with them. So questions, if anybody's got questions, they can either put them in the chat or I guess turn on their microphone. Happy to answer what we can. And if there are none, that's fine. I don't know if Carrie, you're taking it back over or it's moving to somebody else at 1.
If we don't have questions, I believe Rachel is, oh, it looks like Rachel's ready to take over.
Yeah, I can go ahead.
Thank
Thank
you,
you.
Dave and Brent and Rachel.
Hey,
Yep.
thank you all. We really
Thank you.
appreciate the opportunity. Hope it was valuable.
Yep. Bye-bye.
All right, bye-bye now.
Thank you, Dave and Brent. That was valuable and informative and a little scary. So thank you for that. I am going to share my screen. So bear with me while I set this up. All right. If that looks good to everybody, I'll go ahead and introduce myself. And I think I saw Kevin is on here as well. So I'm Rachel Spears. I'm the Executive Director of Pro Bono Partnership of Atlanta. And I am pleased to have with me Kevin Coy here today, who's a partner at Arnold & Gregory and the co-chair of the Privacy and Cybersecurity part of AGG. So thank you, Kevin, for being with us.
Oh, happy to, Rachel. Thank you for the invitation. I hope everyone's enjoying the day and the sessions.
Great. All right. I never miss an opportunity to talk about Pro Bono Partnership of Atlanta. So I'm going to start by doing that briefly. I was watching the names be admitted as they came in. I recognize some of the names. So I know some of you are already familiar with us, but some were new to me. So I would love to tell you about our organization. If I can get this going. There we go. So quick, one note I need to make to y'all is very exciting news. You're going to get professionalism credit for this, unexpected professionalism credit. So after I talk about Pro Bono Partnership, I will cover the required professionalism materials, and then we will dive into our discussion about record keeping. So the mission of Pro Bono Partnership of Atlanta is to provide free legal assistance to nonprofit organizations. I'll tell you a little bit more about our clients. But the flip side of what we do is we provide pro bono opportunities to transactional lawyers, primarily transactional lawyers, both at law firms and in legal departments, who assist our nonprofit clients with their business law matters. Our clients are incredible organizations that serve low-income or disadvantaged individuals in the greater Atlanta area. They provide food, housing, after-school care, job training, all sorts of services to help people in need. In case you work with a nonprofit, I know from experience presenting at the Nonprofit Law CLE, a lot of times we have board members of nonprofits or people that are otherwise involved. So just so you know how to be a client of Pro Bono Partnership of Atlanta, we do require that you be an established 501c3 nonprofit, that you be located in or serve the greater Atlanta area. And we define greater Atlanta about as broadly as you can define it. I know we probably have people from across the state on this call. So we do serve a very wide area around Atlanta. Again, organizations must serve low-income or disadvantaged individuals, be unable to afford legal services, and employ at least one paid staff person. So you can go to our website. There is the link there to apply, find out more about our services. I also want to mention that we have a ton of resources on our website where we work really hard to keep that updated with legal alerts, recordings of past webcasts. We even have a monthly podcast to educate people about legal issues for nonprofits. I encourage you to check that out if you're interested in nonprofit legal issues. And as I said, we provide free legal services to nonprofits by matching them with volunteer attorneys. And you can see on the right some of the areas where our projects come up. Our nonprofit clients are small businesses, and they have the same legal needs of any small business. The top three are the most common requests: reviewing contracts, corporate governance, and employment. Our employment work is primarily employment counsel rather than litigation. We do a significant amount of intellectual property, mainly trademark, copyright, but you can see we have a wide variety of projects for lawyers to help nonprofits. And by the way, when you volunteer to take a project with us, and at the end, I'll kind of talk a little bit more about that, you are only volunteering to handle that one specific project for that client. So it's very discrete projects. Last year alone, we served over 324 nonprofit organizations, provided $8 million in free legal services. We have a staff of 10, so we're only able to do that by engaging many, many volunteers. We had over 1,000 volunteers last year helping our clients on over 1,200 pro bono projects. And I mentioned we have a lot of resources on our website. So we do webcasts, we do podcasts, we do some workshops, and to educate nonprofits. And we did over 40 of those last year. So that's a little bit about Pro Bono Partnership of Atlanta. Now I'll turn to professionalism. So I always like to start this section by talking about Rule 6.1 of the Georgia Rules of Professional Conduct. It's my favorite rule. Lawyers should aspire to render at least 50 hours of pro bono legal services per year. I find in talking to some of my attorney friends that they have forgotten about this from when they took the NPRAE in law school. So I like to remind people we should all be aspiring to render at least 50 hours of pro bono legal services a year. Another thing I want to point out is that it specifies what pro bono work is, and it is providing these services, or the majority of these services, without fee or expectation of fee to either persons of legal limited means or charitable organizations that address the needs of people with limited means. So that is where pro bono partnership falls under this rule, is by providing your free legal services to charitable organizations in matters designed primarily to address the persons of limited means. That is pro bono work. So with our professionalism credit, we need to let you know the bold that any lawyer claiming professionalism credit for this training is deemed to be making a representation that the purpose of completing the CLE is to assist the lawyer with engaging in pro bono representation that the lawyer would otherwise not have been able to perform. So what we're going to be talking about today, record keeping for nonprofits, our kind of ulterior motive is to hope that you will then get involved with Pro Bono Partnership of Atlanta as a volunteer, like Kevin already is, and use your knowledge to help nonprofits with their legal needs. Just a few other materials we need to share. A lawyer's creed. You can review this in the materials, but I like to highlight my favorite sections, which is reminding you that our profession is a calling in the spirit of public service, and we all strive to make the law and our legal system available to all. That is certainly motivates us at Pro Bono Partnership of Atlanta. And similarly, the aspirational statement on professionalism, this is in your materials and has similar statements about the practice of law being a calling in the spirit of public service. So moving on, I want to talk to you a little bit about our clients. And I'm doing this because Kevin and my comments today are kind of targeted on the types of nonprofits that we serve at Pro Bono Partnership Atlanta, and also because we're hoping you will take a project, these are things to keep in mind about our clients. So most of our clients are small to mid-sized nonprofits doing business here in Georgia. Last time I checked, I think 85% of our clients had budgets of less than $1 million. Most have small staffs. Most have very limited capacity and resources. I've been asking our clients lately about what percentage of their funding is federal government funding, because we know that that could be very much impacted, and some of it has already been impacted, and have learned that I've talked to clients that have as much as 85% of their funding coming from federal government funding. So these organizations that already have small staffs may be restricted even further. One thing, let me back up and say the reason I came up with this topic today about record keeping, it doesn't sound like the most exciting thing, but I found that the topic of records has been coming up a lot the last few months. We've been educating ourselves in order to help our clients when it comes to a lot of the new initiatives under the new administration. And a lot of the advice that's been given is for nonprofits to really strengthen their corporate governance practices, to strengthen their compliance, especially those organizations that might be under greater scrutiny because of the type of work they do under this new administration. They want to be really focused on compliance. One of those pieces of compliance we'll talk about is record keeping, having a good record retention and destruction policy, and following that being one example. Last, I want to mention that the last thing we're going to talk about today is open records and some developments in that area. And so it's relevant to know that of the nonprofits we serve, many do have contracts with state, county, and municipal governments to provide services, and therefore may be subject to open records requests. And we're going to talk about that. So that's a little bit about our clients. Now, this is a very general, high-level overview of record keeping today. And I wanted to just kind of put together a lot of different pieces I'm hearing about records so that you all could think about this in your own work, whether that's working at a nonprofit, volunteering at a nonprofit, doing some legal work for nonprofits. And so I wanted to start with kind of my discussions with my clients about records management. The first thing to always think about is, what are records? And I think people are often surprised that it is broader than you may realize. I think the first thing people think of when they think of records are, paper documents. But it also includes everything from photographs, videotapes, and clearly in this day and age, computer-based and generated information. That also includes emails. It includes, text, electronic communications. It includes a lot of things. So I think it's important that your clients understand the scope of what we're talking about here. Now, when I think about why records management is important, I started thinking about kind of the history of records management, at least in the course of my career. And I think years ago, really the focus of records management was really about storage. When documents were paper, it was an issue of space. It was an issue of money to be able to store all that. And coming up with a system to manage records, to dispose of records you no longer needed, was really important. And then while in thinking about storing records, you also wanted to make sure you kept those records. That could be really important down the line if you sold your business or, had some other requirement that you wanted to keep up with. So sort of putting those documents into buckets and thinking about how to keep them. And then, of course, I am old enough to remember Enron and Sarbanes-Oxley, the law that came out of that, which talked about how if you are under investigation or litigation, you should not destroy records and can get in trouble for that. And of course, Congress passed Sarbanes-Oxley, which applies to for-profit companies, but there are two specific provisions that you probably know apply to nonprofits. That is the whistleblower provision, which we're not going to talk about today, and the record retention and destruction provision. And it said, again, if your organization is subject to litigation or investigation, you should not destroy records. And we'll talk a little bit more about that on the next slide. The other thing kind of important to keep in mind in records management overall is there are times when you do have to produce documents, and you want to make sure you're able to find those documents and that you produce documents, only those that are required as opposed to those that you don't want to share. Now, going back to the legal considerations, namely Sarbanes-Oxley, after Sarbanes-Oxley, the IRS amended the Form 990 to ask some additional questions that really related to corporate governance. And I tell my nonprofit clients, when you're answering these questions, it's not like you're going to fail based on your answer, but it's not a good look. The IRS clearly wants you to answer these questions a certain way, and is motivating you to change your practices so you can answer these questions kind of the right way. So specifically, the questions I'm talking about are those corporate governance questions, including, do you have a record retention and destruction policy? You want to be able to say yes. If you're a 501c3 organization, especially because, as we know, those 990s are public records and available on GuideStar. Now, this is, I believe, only on the long form 990, not the 990EZ, certainly not the 990N, but still something for organizations of all sizes to keep in mind. The next legal consideration when it comes to your records is privacy. And that's why we have Kevin here today, our expert on privacy, to talk about all the many things you need to consider about that. It seems to me like this has been a much bigger issue the past 10 years or so, maybe 20 years, but certainly in the past 10 years.
Yeah, that's right, Rachel. I mean, there's privacy and also security concerns have been increasing, particularly as records have been digitized. 25 years ago, when records were primarily paper, there were still risks, of course, but not the same sorts of risks that we have today with internet connectivity and digital records, where hackers or other bad actors can potentially get in, or where someone can even inadvertently expose a large volume of data with a few clicks, as opposed to what would have been necessary to compromise that volume of data in the past. And for the record retention issue, it is becoming an increased area of concern under privacy laws as those continue to evolve. Privacy laws, generally speaking, don't dictate specific retention periods, although that can happen from time to time under some laws. The broader privacy concern is that you keep any promises you make regarding retention, so that if you're telling someone you're only going to keep personal information about them for a certain period of time, that you keep those promises. And also the concept of data minimization, that you only collect information that you need and you only retain it as long as you need it to accomplish those tasks, so that you're not accumulating large quantities of personal information which you no longer need, but if compromised could create a significant data breach, could create significant risk to the individuals about whom you've collected the information if it's been compromised.
Thank you, Kevin. And you mentioned your agreements, and that's the next step is your contractual and legal requirements. So what have you agreed to under contract in terms of your records and making sure you maintain those agreements? And any other legal requirements, certain organizations might be required, for example, by state law to keep certain records. Finally, open records law. I would not have had this on this list a year ago, but with the court decision that we will talk about later, we decided to add this because for Georgia nonprofits, Georgia organizations in general, it's important to keep in mind whether the open records law might apply to you and something you need to factor in as you're thinking about your records. So next up, this follows what you were just talking about, Kevin, the data minimization. This is, again, just something I like to share with my clients about data, especially when it comes to data you're collecting from other people. For nonprofits, is typically from your clients, for participants in your programs, for volunteers, things like that. So I like them to be thinking about when they're collecting data, particularly any PII, personally identifiable sensitive information. Number one, do you need to collect it? And I remember when I signed up my kids for some field trip, and this was years ago, but they had on there their social security number. I was like, not sure you need that. But think about, do you really need to collect that sensitive information? And then number two, if you do need to collect it, let's say you're performing a background check on volunteers and you need it because you're doing a background check based on social security numbers. Do you need to keep that information, or can you dispose of it as soon as you're done with it? If you do need to keep it for some reason, how can you protect that data while it's in your possession? This is really important. We've had many clients deal with stolen laptops, or somebody who threw a bunch of records in the dumpster in the back, things like that. How can you protect that data if you do need to keep it? And then last, when you no longer need it, when can you dispose of it? And I should add, and how to properly dispose of it. Again, keeping in mind protecting that data. Before I move on, Kevin, you have anything to add about data minimization? I can't even say that word, data minimization.
Rachel, no, I think you hit the key points there. I think I would add, just sort of picking up on your camp example from back in the day, whether the information is needed in the first place, or whether the needs of the organization have changed. Sometimes there's sort of just inertia that we've asked for the social security number on this form forever, without considering, have circumstances changed, even if we needed it back in the day for some reason, do we still need it today? And periodically reviewing forms and information requests to assess whether you still need the information and what you need it for, as well as whether there's some less obtrusive means of collecting information to accomplish your purpose. So if you need a unique identifier, does it have to be the social security number, or instead could it be some other identification number, even if it's one that's internally generated within the organization, so that it's member 123 or donor 345, whatever the case might be.
Right, those are good conversations to be having with the organization. So next, I'm going to talk about document retention policies. And as I mentioned, this IRS added a question. I think it was around, well, I can't even remember when it was. It was a long time ago, 20 years ago or something, maybe. Maybe not that long, where they added to the 990 this question about, do you have a document retention and destruction policy? Hoping you would say yes. And in the instructions on the Form 990, they defined what that meant, what they meant by that. And it says it's a policy that identifies the record retention responsibilities of staff, volunteers, board members, and outsiders for maintaining and documenting the storage and destruction of the organization's documents and records. I want to point out here that the IRS specifies that it includes the responsibilities of staff, and knowing that you're a nonprofit, volunteers, board members, and outsiders. So that's something to keep in mind when you're looking at your document retention policy. So we already covered some of why you should have a good policy. It is a good, whether the IRS tells you have to have one or not, it's generally a good corporate practice. It's part of your board doing their duty of care, making sure you are have a policy for both the retention and destruction of documents. And in the case of litigation, you really want to show that you have a schedule, a process for disposing of documents, so you're not raising, issues by destroying documents at maybe a suspicious time or something. So it can be, it's a good practice if you may be subject to litigation. So when it comes to your document retention policy, things to keep in mind, the policy should identify who all must comply with the policy. Again, going back to the IRS instructions, you should include volunteers, board members, etc. You should identify one person who is ultimately responsible for compliance with a small nonprofit. That could be the executive director or a larger organization. You could designate a staff member to be responsible for this. Identify the relevant types of documents for your organization. All of us have articles and contracts and employee records, but what are those documents that are specific to your organization that you want to make sure you cover? And for each of those buckets of documents, coming up with a schedule for retention and deletion. And I'll talk about how you come up with those on the next slide. But be sure to include documents, that may be on people's personal devices. And we'll talk about best practices around that. But think, again, very broadly about what a document includes. Importantly, specify a schedule, a timing for both audits of your records and disposal of records that you no longer need under the policy. And again, if you are, in a situation where you're facing litigation or investigation, you want to show that you have a schedule for destroying documents, and that is what you have followed. But if you are indeed notified that you are subject to a litigation or investigation, above all else, this policy needs to say, in the case of litigation or investigation, all of this is out the window and you will not destroy documents. As far as retention periods, this is where you should look at state law. For example, here in Georgia, requires permanent retention of all records for actions taken by a board without a meeting. So like a unanimous consent resolution, for example, you need to keep that permanently. Or records for actions taken by a committee without the full board approval. Those are types of things that you're actually required to maintain permanently. So check state law for specific retention requirements that might apply to your organization in general, or your specific type of organization. You also want to think about the statute of limitations and how it might impact how long you need to retain documents. For example, any employee-related documents, you need to look at the statute of limitations for employment type claims and make sure you keep any relevant documents for at least that time period. This is a little off topic, but while we're talking about employee documents, I want to mention the importance of keeping any health records for your employees separate from your general HR documents and keeping your I-9 forms separate as well. These are documents that you may need to pull and you don't want to all together. You should have those separated out. When it comes to statute of limitation for contracts, you want to make sure whatever retention policies you have for contracts cover the lifetime of the contract plus that statute of limitations that might apply. For IRS records, when it comes to the Form 1023, this is the form you submitted to get your 501c3 status. Because of the IRS public disclosure requirements, you can be asked to provide that to anyone at any time. So every organization should have that document, should know where it is. We've had plenty of clients not know where it is, and we advise them to contact the IRS to get a copy of that and then not lose it again, because you are required to keep that permanently. When it comes to 990s, you're supposed to keep those at least 3 years, but I am afraid to get rid of mine. I keep those forever. And then let's see, the I-9, I mentioned this because this is a question we are hearing a lot about lately. And I know, by the way, next week, Anton Mertens, I believe Kevin's partner, is going to speak to y'all about immigration issues. But since we're talking about records, want to mention that those I-9s for your employees, you want to keep 3 years after the data hire, or 1 year after termination, whichever is later. I just went through and did this with my employee records, and anybody that had been at the organization at least 3 years, I just waited 1 year after termination, and that is when we were able to dispose of records. And then retention periods for routine emails and messages. This is, I must admit, a little harder to follow, but it's considered a best practice to delete those. Have a actually deletion protocol. I think this is something you can work with your IT folks to delete those after 90 days or up to a year. So when it comes to the retention periods, I think this is something you can take a template, you can take a form from somewhere. There's some good ones you can find, like I know the National Council for Nonprofits has a resource with some links to some, but you really need to look at those retention periods, make sure they meet the requirements of your state and your organization's needs. Just continuing about the retention, some other types of documents you may want to maintain permanently, certainly your corporate documents, your articles. I mentioned the IRS documents, minutes, deeds and mortgages, certainly your patents, trademarks, that kind of things. There's certain things you're just going to want to have a system for maintaining forever. And then when it comes to personal devices, this is something that's good to put in this policy. You might prohibit the use of personal email addresses for work-related correspondence and the use of text messages for substantive work, because that would be considered a record under your record retention policy. And how do you manage that? How do you manage production or destruction of something on my phone? So that's a good idea to prohibit your employees from using kind of personal email or personal text that could be subject to some sort of a record production. Similarly, don't allow employees to store documents on their personal devices, work-related documents. And so because people work remotely, because people are out and about, it's really important to have the technology set up that your employees, even when they're out working, can get their records onto a work device, a work program, so that they can be accessed. All right, now I'm going to turn to record production. And what I mean by that is sometimes your organization might be required or requested or required to produce records. And this may come up if in the event of a government investigation or audit, for example. It's been in the news recently about a government investigation that has pulled in some major nonprofits related to some EPA funding last year. So it's certainly some on the minds of some nonprofits. You might be subject to a search warrant, particularly we're hearing about ICE warrants as being something nonprofits are concerned about. Or you might get a subpoena. This is what we have seen most often with our clients, third-party subpoenas. And so I'll talk about that specifically. And let me just go ahead and say I am not a litigator. I've told Kevin this too. I'm not a litigator here. So this is what I have learned just working with our nonprofit clients that get these requests. So what to do if you get one? First of all, make sure the nonprofit staff knows what to do. If they get a document asking for records, make sure that they notify leadership, or if you have a designated person to receive these, make sure they know who that is, and make sure they know not to destroy anything when they get that. Just turn over the letter, have the right person look at it. You might want to give them some examples of some types of documents that you all receive so they know what it looks like and what to do with it. And then the person who receives it will determine whether they should go ahead and issue a litigation hold under any relevant documents as soon as possible. Whoever is reviewing that should, number one, call a lawyer, but I think it's important to have them look at kind of the who is who in this, who is being served, who is named on there, document when you received this request, make sure they're asking the right party, see who is asking. Is this a warrant from a judge or is it a letter from a law firm? Like, who is asking for this? What information they are asking for specifically. And when it comes to what information they're asking for, there are some unique considerations maybe for your organization. If you're a healthcare organization subject to HIPAA, there's certainly going to be some regulations around that. If you serve students, if you're a school, then you're going to have to deal with FERPA. And then there might be some attorney-client privileges issues as well. So think about the type of information and what it might be subject to. And then, of course, look at the deadline for producing those, or what they say is the deadline. As I mentioned, what we see most of all for our clients is third-party subpoenas, third-party requests for documents, that sort of thing. And what we find that with our clients, a lot of times, if it's a letter from a law firm, a call to that law firm, talking through what are you looking for, when do you really need this, here are our concerns, kind of talking it through can often resolve that in a way that our clients get comfortable with producing some limited information, or say they just can't do it. A lot of times that is actually resolved that way, but there are times when it comes to requiring us to find a volunteer attorney to serve written objections to that, or filing motions to quash. There are, I know we serve a lot of domestic violence organizations, and there are some provisions under, I think, the Violence Against Women's Act that limit their ability to produce certain things. So sometimes we have to pull those in. Another way to approach this is to contact the party that is on the other side of the requestor. So a lot of times we see these come from family law kind of disputes. And one party will contact our client looking for information about, children in their childcare program or something like that. And in this case, you would contact the person on the other side of that family law dispute and say, why don't you object to our producing this? So that's another way to handle it. And then finally, another option is to comply with the subpoena and provide the testimony or documents if there are no limitations on your ability to do so. So I want to mention ICE enforcement. Again, Anton is probably going to cover this in the immigration section next week, but this is another way where you might get a request for production of documents or a warrant served on your organization. And it's really important, we are finding, to prepare and train your employees if you feel like you might be subject to that based on who you serve, that you train and prepare your employees. We suggest developing some checklists that they can easily reference in the event of something like that. Now I am going to turn it over to Kevin to talk about data privacy and security.
Thanks, Rachel. And thank you also in advance for advancing the slides for me. First, just by way of background, as we were talking about a little bit earlier, privacy and data security has taken on increased importance over the years as technology has advanced and as sensitivity to privacy issues has expanded, particularly with the expansion of internet-based activities, social media platforms, and all of the technologies that go along with that. And now newer technologies like generative AI, that there's an increased sensitivity to privacy issues. So the first thing to really say here is that virtually every organization has privacy and data security law issues, even if your core business is not focused on personal data, because at a minimum, virtually everybody has employees, and you're collecting personal data as part of the employment process. And there are sensitivities around that. The other areas that Rachel already identified in terms of I-9 compliance and potentially collecting health information with respect to benefits plans, collecting information about employee or applicant activities, background screening. So that at a minimum, and then in addition, most organizations are likely collecting information about, in the nonprofit context, the communities that they're serving. That could be, or others that are supporting their operations, their volunteers, their donors, if they're in the health space, their patients, students in the case of schools, or applicants. So lots of potential avenues and different audiences where privacy and data security concerns are a factor. And privacy, unlike some other areas of law, privacy and data security law really is continuing to evolve. And so there's a lot of change in this space, more so at the state level than the federal level. But we have continuing developments under case law. We have new statutory enactments, again, those primarily coming from the states these days rather than the federal government, although the federal government is attempting to do that in a variety of areas. And so today we'll focus on a few areas where nonprofits may encounter privacy and data security law issues. And from a liability standpoint, potential exposure varies by the law, but potential exposure under some privacy laws can be substantial. It can be the basis for potential class actions under some privacy laws if there's a liability issue there. And so something to be sensitive to, not only from the privacy perspective, but from the liability perspective as well. And one other thing to say about this, more broadly speaking, Rachel earlier sort of mentioned the pro bono partnerships general focus on smaller nonprofits in the greater Atlanta area. And with that in mind, we're focusing primarily on federal and Georgia considerations, but wanted to emphasize that in the privacy and data security space, you may not be limited to Georgia and federal law here, because privacy law and data security law often, particularly when it's done from a state law perspective, focuses on, in most cases, residents of the state. And so if your nonprofit is operating on a multi-state basis, so even if you're primarily here in Atlanta and operating primarily here in Georgia, if you have a broader footprint and you're operating on a multi-state basis or a national basis, you could have state law considerations in other jurisdictions. That could be in the event of a data breach. It could be a data security requirement. It could be some other things that we'll talk about a few examples of. So I just wanted to flag that your footprint and where you're operating, who you're dealing with from a privacy and cybersecurity perspective could impact which laws apply to you and how you address those laws. And while we're focusing today primarily on Georgia and a broader US footprint, that would also be true if your nonprofit has an international reach, because many other countries also have detailed privacy and data security laws, some of which are more rigorous in some respects than what we have here in the US. So while we're not really talking about them today, just a bookmark that if you do have international activities, other international privacy and data security laws could come into play as well. One area to talk about is privacy policies and notices. Many organizations today, whether legally required or not, have privacy policies or notices that they've posted on their websites that they include in various communications. And that can raise some issues with respect to potential exposure. First, from a general perspective, under federal law, the Section 5 of the Federal Trade Commission Act prohibits unfair or deceptive acts and practices. And virtually every state has its own mini UDAP statute. For nonprofits, Section 5 of the FTC Act generally does not apply. There are a couple of exceptions around instances where a nonprofit might have also for-profit activities, but they're generally excluded. That's not true of all the state UDAP statutes. Applicability there varies in terms of whether nonprofits are potentially subject to those laws. I mention them because in the absence of more detailed privacy laws, the Federal Trade Commission and the state attorney generals often look to their UDAP authority to bring privacy and data security actions. Federal Trade Commission's brought roughly 90 data security cases so far and a number of privacy cases as well over the years. And they argue that either a privacy promise that an organization made hasn't been kept, and therefore it's a violation. There's some more tests around that, but that's the core thrust of it. Or they're engaging in a practice that is unfair to consumers because consumers don't necessarily have a choice, and the data security approaches, for example, taken by an organization were inadequate and it's unfair to consumers. Those types of cases are a possibility, particularly in jurisdictions where the UDAPs apply to nonprofits, but it's also just sort of a good practice general sense to review your privacy policies, your privacy notices, to be confident that what you're saying in those policies actually reflect your actual practices, because that's one of the core pieces behind the deceptive acts or practices type of claim. An organization made a privacy promise to me. I relied on that privacy promise. They didn't keep that privacy promise, and I suffered as a result. Either a consumer trying to make that type of claim directly, or more likely from an enforcement perspective, it's an agency coming in and taking that position on behalf of the consumer. You also could have requirements with respect to privacy policies and notices for state or federal law requirements, and applicability here again varies. Rachel mentioned examples of HIPAA and FERPA, for example, for organizations that are subject to those laws. At the federal level, there also could be requirements for under other federal statutes, but most of these requirements are likely to come from state privacy laws, and in particular, the new generation of privacy laws that have been enacted since California passed its new generation of privacy laws in 2018. Today, about 20 states have adopted new generations of privacy laws. Many of those do not apply to nonprofits, but some of them do. So again, depending on your organization's footprint and also other triggers potentially in these laws regarding things like revenue or the number of individuals, the number of state residents you're collecting information about, these laws could apply. And if they do, they typically have requirements for privacy notices. Georgia hasn't adopted one of these new generation laws yet, but there are bills under consideration in the legislature. One of those bills includes a partial exception for nonprofits where it would not apply to a nonprofit unless the nonprofit sells personal information. So if that bill were to be enacted, most nonprofits would potentially be exempt, but if the nonprofit is selling personal information, then they would be in scope, assuming, again, if that bill were enacted in its current form. Other issues to consider, not necessarily in the privacy policy or notice, although sometimes they are referenced there. Other privacy issues sometimes come up with respect to call recordings. This creates an issue under potentially under federal and state wiretapping laws. Under the federal rules and the rules in the majority of states, only one party needs to consent to the recording of a call, but there are about a dozen states that require all parties to consent. That consent standard, in terms of what that consent looks like, isn't necessarily a particularly rigorous standard, and everybody on the call has probably heard those messages when calling into call centers or other activities that say, you know, this call is subject to being recorded for quality control or educational purposes or record keeping purposes or whatever the case might be. But to note that Georgia is a one-party state, but again, depending on your footprint, the two-party state laws could be relevant. There was a case from the California Supreme Court, for example. California is an all-party consent state, where a California consumer called a business in Georgia, and that call was recorded. The consumer sued, alleging that the requirements to obtain their consent had not been satisfied. And the California Supreme Court agreed that the California statute applied in that case because the consumer was in California. They had interactions with the business from California, and they concluded that the California law should apply in that case, even though the other party to the call was in Georgia, which was only a one-party consent state. Another area to consider with respect to privacy policies and notices is whether you have any additional requirements beyond state requirements. This could be contractually required or mandated by third-party partners. For example, if you are, for your website, using various types of tracking technology, your terms and conditions with the provider of those services might include terms that require you say something in your privacy policy about their technology, or potentially pointing to their opportunities for opting out of use of their tool. And so it's something to keep an eye on with respect to your contracts with various vendors as to whether or not they're trying to flow down privacy notice requirements to you, to have you put content in your privacy notice or address specific things in your privacy notice related to the services that they're providing to you. Similarly, when you look to your downstream vendors and contracts, privacy notices will often include language about disclosures to third parties and to contractors. And you want to, again, make sure that whatever you're promising in your privacy policy is something that you're able to keep through your contracts. Usually, those promises are fairly high level in terms of restricting the vendor to be able to use this, limiting their use of personal information you might give them to carrying out your contracts, and also keeping the data secure. But sometimes additional language creeps into the privacy policies or is intentionally inserted, which talks about additional restrictions or requiring background checks on the vendors or other more granular requirements. You can have those certainly, but if you do have those, you'd want to make sure that all of your relevant contracts actually have provisions flowing those requirements downstream to your vendors. And the other point I just wanted to mention here is with respect to Charity Navigator. They have a requirement for a donor-specific privacy policy. Currently, their rules, as I understand it, is that that's only necessary for large nonprofits with assets over $50 million or income over $50 million a year. But even smaller charities sometimes choose to have those policies, which is perfectly fine. You just want to think through what your practices with respect to information about your donors are, and make sure, again, that that policy is accurate and reflects your practices with respect to sale of donor lists or other activities involving donor data.
Kevin, just want to point out the time.
Yep. No, thanks, Rachel. Saw that. From a security perspective, as I mentioned, the FTC has brought over 90 data security cases. You often see those in the headlines. State actions are also possible, even if those laws are not directly applicable to your nonprofit. It's often worthwhile keeping an eye on those cases when they're announced, because they often point out vulnerabilities that organizations may have broadly from a data security perspective or data privacy perspective that could be exploited to harm nonprofits as well as for-profit organizations. From a data security perspective, many states have laws on data security and or data disposal beyond the UDAP statutes that we were talking about. Most of these are written at a relatively high level, saying that personal data must be disposed of in a secure manner. Georgia, for example, has a data disposal law there, 1015-2, which applies to certain types of personal data. And if you have that type of personal data, whether it's medical records or certain financial or other account information, it requires that electronic records be destroyed securely through means such as erasure, that paper records be shredded, or that steps be taken to make sure that the information is not interpretable, that it's unclear. The other states have more detailed requirements. Massachusetts, for example, gets fairly granular in its security requirements, as do some federal laws. HIPAA has a detailed security rule. So if you're subject to the health information rules there, you have to have an entire security program. The Fair Credit Reporting Act also requires that if you get a consumer report, whether it's about your employees or about others, that be disposed of in a secure manner when you get ready to dispose it. Breach notification laws vary by state in terms of their content. Georgia doesn't have a particularly strong breach notification law, but again, those laws are based on the residence of the individual. So if you have individuals from multiple states, you could have additional notice obligations. Similarly, as I mentioned at the outset, employee privacy issues. Everybody has employees. If you're doing background checks on them, and there was some mention of that in the prior insurance session, you have requirements under the Fair Credit Reporting Act to obtain authorization from the individual to obtain those reports. You have to provide them certain notices. You have adverse action obligations with respect to that information. The Fair Credit Reporting Act has a private right of action, and it's generated a lot of class action activity. So it's something to take a look at if you're doing background checks to make sure that everything's buttoned down in that area. In addition, some jurisdictions have fair chance and ban the box laws, which impose additional requirements here in terms of doing things like prohibiting an employer from asking about criminal history on an application, or potentially until there's been a conditional offer of employment, and puts other controls in place there. Similarly, from a general privacy notice obligation standpoint, some states apply their laws, primarily California here, to employees. And so you would have to have a privacy notice for your employees or your applicants, as well as for your donors or others. Some states have biometric privacy laws, although not Georgia currently. And HIPAA, again, can apply to a variety of employee health benefit plans, so you could have additional obligations there.
I feel like we've covered this.
Yeah, we've covered a lot of this, I think, Rachel, just to sort of sum it up in terms of steps, and we've touched on some of these along the way. Important to understand what personal data you're collecting, for what purposes, and how you retain it. And Rachel, I know we've still got the open records content and stuff, so I'll just sort of stop there so we can move forward.
All right, let's see. Anything on this one, Kevin?
Just education and training about your security practices, and protecting and training folks to try in particular to avoid phishing exercises and other social engineering attempts to gain access to your personal information.
Okay, great. All right, we've been teasing this along the way, so I want to mention open records request, because there have been some developments here in Georgia. Any individual can submit a request to an agency, and we'll talk about what an agency is, to copy and inspect public records. There are some exemptions to what must be disclosed, but the agency that this applies to, of course, state, county, or municipal government, also specifically includes in the statute nonprofits that receive more than 1/3 of their funding from a direct tax allocation. I have had very few clients that have actually been covered by this. I think the one case example is, I think it was a sexual assault center in Athens that did meet the requirements of the statute because of a tax allocation. More often, there was another case, famous case for Piedmont Park Conservancy, that found that they were subject to it because they carry out a government function, namely managing Piedmont Park on behalf of the city of Atlanta. But the new development we wanted to bring to your attention is this last one for government contractors, such that specifically anybody already subject to the statute was anybody who held government records. And that includes, nonprofits, even private entities, including nonprofits that may be providing services on behalf of the state and may be holding records for that. But we'll talk about the new development on this. First, I want to just say the requirements of open records laws require that the recipient of a request respond with a reasonable amount of time, generally no more than 3 business days. So that's a quick turnaround. They must make arrangements for someone to come in and inspect those records or copy them, or must provide a description of what they have and when they will provide it. Allows for the agency to collect costs of production. And if there is an exemption to producing documents, you must cite that specific exemption. Of course, when it comes to records that contain personal information, you must protect that personal information by redacting it, etc. And then lastly, any agency that fails to comply with an open records request can face civil criminal liability, specifically pretty significant fines. So what we wanted to bring your attention to is that there was a Supreme Court case last year, Milleron, where that provides that a private individual can submit an open records request to a private entity directly. It does not have to go to a government agency. You can submit it to any private entity that is holding government records. That includes nonprofits. So if you're a nonprofit that has a contract with the government to provide services and you have records that you are holding either on behalf of the government or relative to your services you're providing, you are subject to the open records law. And this is a new development a lot of people weren't aware of and has caused quite a bit of alarm among our clients. And so quickly to prepare, you want to really think about, are you subject to this act? If so, what records might be covered? How can you look at your record keeping policy to make sure you're prepared to respond in a timely fashion to these requests? And develop a process for responding to them. Make sure you have one designated person, again, in charge of handling them, and make sure everybody knows to get any requests to that person quickly. So let's see, Kevin, I'm going to turn it over to you to talk about this legislation regarding the open records law.
Thanks, Rachel. The legislature has a bill under consideration that would partially reverse the Milleron decision. It would define custodian or lawful custodian to effectively be the agency, and it would require requests to for public records to be made upon a custodian. There would still, though, be under this, if it were enacted, a responsibility for private persons, but that would be through the agency. So an agency would then be required to reach out to potentially contractors to require them to produce records in response to the request for the custodian. So there would still be a role here, responsibility here for private contractors, but it would be limited to requests that they receive from the agencies as opposed to directly from members of the public. That was filed in January. It passed the state Senate on February 21st with no opposition. There were a few absences and a few abstentions, but overwhelmingly in favor. It's currently pending in the Assembly. Unclear when the Assembly might finally pass it. But when it is passed, is currently written, it would take immediate effect should it be signed by the governor. So there may be a fix in the works here, but it's not in place yet. And so in the meantime, important to consider all the points that Rachel made in terms of how you might handle such a request if you received one.
Thank you, Kevin. And just very quickly, I mentioned that we're hoping you will volunteer for projects. We've got projects related to the topics we discussed today. We have lots of types of projects, not just this. So I encourage you to check out our website and see what projects we have. But specific to this, we have volunteers draft document retention policies. We have a form that we're actually in the process of revising that we can offer to you in doing that project. We need help for clients who have to respond to third-party subpoenas. We have clients right now looking for help responding to for the policies and procedures for responding to open records requests. Even if this bill is passed, they may have to, comply with an agency looking for these documents that received a request. And we often have nonprofits looking for help drafting privacy policies. This is something Kevin helps us with regularly. And just want to end with our website, encourage you to check it out. That's a link to sign up for our email with volunteer opportunities once a month and to check out our current volunteer opportunities. So I hope this motivates you to take a pro bono project through Pro Bono Partnership of Atlanta. And I hope this information was helpful to you. And I want to thank Kevin very much for joining me today.
Well, happy to do it, Rachel. Appreciate the opportunity.
All right. Thanks, everybody.
Thanks to you both and to Brent and Dave as well.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.